Hello and warm welcome to everyone joining us today. You may find yourselves here after watching my earlier webinar on AI and copyright protection, or you may be new to our webinars on this topic. Today's focus is going to be on helping you understand practical considerations of the Getty Images versus Stability AI judgment. And what we will cover is what was the case about, why is it important, why does it matter to you professionally, what was the outcome of the Getty Images versus Stability AI case, which was decided by the High Court. What are the implications for AI developers and users? And as well, what is the impact of this case on content creators and rights holders, particularly in the context of copyright, but also in the context of trademark law and branding? We will also try to shed some light on what the potential future holds for generative AI and copyright law. My name is Gosia Evans. I'm a senior intellectual property dispute resolution lawyer at Harper James. I have over 14 years experience in intellectual property and commercial disputes. Just so you're aware, this webinar is only for general information purposes and its content does not constitute any legal advice. If you have any specific legal queries that we may be able to assist you with, please don't hesitate to contact us directly. So what was the Getty Images and Stability AI case about? You may have seen a lot of content produced about this case in the last few weeks, and let's try to unpick a little bit why the case is important and what the background to it is to help you understand it. Getty Images sued Stability AI, who is the developer of Stable Diffusion AI model, in respect of copyright infringement, in respect of trademark infringement, and in respect of passing off. We won't go into the detail of each of those claims because there were multiple different allegations involved in each of those grounds. But suffice to say that Getty Images claimed that millions of its watermarked images that were protected by copyright were copied by Stable Diffusion in order for it to be trained without permission of the rights owners. The High Court, in its decision, largely sided with Stability AI and rejected most of Getty Images' claims. The case exposed some gaps between technological innovation and existing intellectual property laws, particularly in the area of copyright, which we will discuss shortly. So what was the outcome of this case? In relation to primary copyright infringement, unfortunately, we didn't receive a response from the court in relation to that ground. And this is because the claim in primary copyright infringement issued by Getty was dropped earlier in the proceedings for jurisdictional reasons. This is because Stable Diffusion was trained in the US on US servers as opposed to being trained in the United Kingdom. And it was established that there was not a sufficient link to the UK for that claim to proceed. In relation to secondary infringement to copyright, the High Court found that Stable Diffusion did not store or reproduce Getty's works, and as such, it was not considered to be an infringing article in itself. There were also trademark infringement claims made by Getty, and in relation to those, Getty succeeded in part, so succeeded on some grounds, but not on other grounds. And those related to Stability AI model using Getty Images and iStock trademarks in the course of trade. Passing off claim due to the fact that the registered trademark infringement claims were in part successful for Getty. This claim was not pursued. There was no determination from High Courts in that regard. So the implications for AI developers and users are as follows. From the perspective of AI developer, what you need to be paying specific attention to is making sure that you maintain transparency and records of training data. Coming back to the point I've made when we were discussing the previous slide, this is important because transparency in records of where the training is taking place will definitely be relevant for the purposes of establishing connection between the location of training and the jurisdiction, such as the UK or outside of the UK. And that will in turn determine whether certain claims can proceed in the UK or not. As a general rule, developers of AI systems would be well advised to avoid including any material as part of training that is subject to copyright protection or that includes branding that may be subject to registered trademark protection or passing off claims in the UK. This, generally speaking, should not be included in datasets. Now, we know in reality this is not the case, and we know that certain risks inevitably will already exist in existing AI models, but this is really a tip for future development. In relation to the models themselves, it would be useful for developers to make sure that they incorporate compliance and review mechanisms throughout the process of developing such models. Now, from the perspective of AI users, there is really no change to the risk that still exists of creating generative AI output. If it includes any distinctive elements that are still protected of works that are still protected by copyright, and if it can be proved that the model used works protected by copyright this way, just through obvious use of this substantial part of the work, the risk of a successful copyright claim still exists. And as it stands, the liability of a user will effectively depend on who controlled the development process of work created through generative AI and whether it was used for commercial purposes. Now, that situation may be subject to change because as it stands, there is a potential as well for AI developers to also be held liable in respect of copyright infringement. Is that control element in creation of such work that would likely be considered a determining factor, and that's assessed on the facts of the case. So we cannot give sort of a blanket indication as to who might be liable in respect of copyright infringement. But the key message is that generally the case and the current legal position does not remove a potential legal liability in respect of use of AI for the use of copyright protected works in AI training or in respect of AI output, but it may potentially have some limitations in respect of jurisdiction. The decision is also relevant from the perspective of brand protection and trademarks in the UK. In relation to using logos, watermarks, or branding, such use for the purpose of AI training and also for the purpose of generative AI can potentially constitute registered trademark infringement or passing off. And this happens in a situation where generative AI replicates brands in the course of trade, because this is one of the key factors in determining whether registered trademark infringement has occurred. And if those criteria are satisfied, the developers and users can potentially be held liable in respect of registered trademark infringement or passing off if we're talking about unregistered marks. So brand owners should certainly monitor whether the generative AI outputs, whether created by them or whether created predominantly by third parties, includes any of their marks within the content. And if that's the case, then they would be well advised to contact an intellectual property professional for further advice. You need to be aware of whether the AI system that you're creating and using is actually using third-party branding, because that might effectively lead to liability in registered trademark infringement and or passing off. So in terms of the content creators and rights holders and the impact of Getty Images versus Stability AI judgment, it may be a problematic judgment from perspective of the content creators who are now in a situation whereby there isn't an effective legal protection against AI systems that are trained outside of the United Kingdom and they use copyright protected works outside of the United Kingdom for the purpose of training. This is because of the fact that, as mentioned earlier in this presentation, the secondary copyright infringement claim brought by Getty failed. Of course, there is also has always been a risk, and it remains a risk, that holders, owners of copyright are unable, or increasingly it becomes more and more difficult to trace how the copyright protected works are being used by any AI model. So effectively, there is now a situation whereby, unless it is very clear from the outputs that the AI model must have been trained on a copyright protected work, and if that work hasn't been put into training for the AI model in the UK, it's a very difficult claim to bring as it stands. So quite clearly, there is a situation whereby it creates a certain level of risk for all particularly content creators and rights holders in respect of copyright protection. So businesses and rights holders should at this stage implement AI safe licenses that define permitted use of their works, particularly if the works are present in the digital environment. This would be a recommended step. They should also consider strengthening indemnities and audit rights in all of their commercial contracts in respect of AI training and AI generative works in the context of use of their works, particularly protected by copyright. And also they should monitor the use of their content in AI data sets and outputs. But like I said at the beginning of this slide, we appreciate that from a practical point of view, it's a very, very difficult task for copyright owners. What does the future hold for generative AI and copyright law? So the UK government is currently debating how to proceed in the best way in relation to balancing the interests between copyright holders and creators and developers and users. And the consultation documents produced by the government outlined generally 4 broad policy options for reform. We don't know which one of them will be eventually followed. The legislation has not been finalised, but we do have some indications that it will be put in place in 2026. And we're very hopeful because at this stage, we do have some gaps in protection, particularly in the context of training, but also there are question marks in relation to liability. So it would be immensely helpful if the government focused on developing this area with some transparency and clarity. The practical considerations as we head into 2026 before the legislation comes into force, whatever the government might decide, you may wish to think about whether AI models and their training data sets are actually prepared for what may come next year. And from that point of view, it's that transparency element, it's that accountability element. So are you prepared, particularly if you're an AI developer, for a regime whereby you may be required to account for and possibly license the copyright protected works that you have used or that you intend to use in the future? Does your organization, if it uses AI, does it have traceability and audit mechanisms, particularly for the purpose of showing how AI systems, how AI models used works and to what extent and at what time? And also, how can you trace how those works, if at all, have been reproduced in generative AI outputs? If the UK introduces an opt-out model, which is one of the models that has been considered as part of the consultation, what will be the impact on rights holders' ability to say no to their works being used for the purpose of AI training? And how, if you are the AI developer, what will be the response from your organization? Because it is one of the considerations whereby copyright holders might have that option to refuse permission of they copyright protected works to be used for the purpose of training of AI models. And what would that mean for your current business? And then what might happen in a situation if the UK diverges from other jurisdictions? If you operate on an international basis, or for example, you operate in the UK or in the EU, would this have an impact or direct impact on your business? It's an interesting question because as it stands, of course, we've only just recently had the judgment in Getty Images and Stability AI in the UK. And about a week and a half later, the Munich court issued a judgment in Gamer versus OpenAI. And this is the judgment that was published, which actually went opposite way to Getty Images versus Stability AI, in that it was recognized that because the AI model had the ability to recreate a certain works, which in this case it involved literary copyright in musical lyrics. It wasn't a necessity for the AI model to store a copy of those lyrics, but it had all the tools, so mechanical tools, whatever they might be, to be able to replicate those lyrics, and that in itself is potentially problematic, is creating liability in respect of copyright infringement. Now, of course, this is a German decision. It's based in a different jurisdiction and different legal system, and different considerations would have come into play for the judges in this case. But as a general rule, for the purpose of copyright protection, and also from business perspective, it would be beneficial for the UK system and the EU system to be aligned purely because of the business between the two jurisdictions. And it would not be a preferable option for those jurisdictions to have a very significantly different approach to AI and copyright protection. So it will be interesting how the government is going to consider the two decisions and the way in which both separate jurisdictions are going at the moment. and what the decision is going to be in relation to the statutory regime in the UK. If you would like to find out more about this topic, you are most welcome to contact us in several different ways, which you can see in the slide. You can contact us by telephone or by sending us an email. Please reach out. We have got a number of offices across the UK, and we would be delighted to hear from you if you've got any questions. Thank you very much for your attention today.